Welcome, Consumer Law 101 viewers. My name is Mike Haddad. I'm the CTO of Swift Law North. Joining us today is Aaron Swift. He's the CEO of Swift Law North. How are you, Aaron?
Good, Mike. Thanks.
All right, today's lecture video is the second in our FCRA 101 series and is titled ABCs of the FCRA, Part 2, Important Definitions and Legal Standards. All right, so let's start here. What are the important FCRA definitions credit professionals need to know?
So to start, Mike, let's begin with who does the FCRA apply to? We talked about definitions about the FDCPA in the video in that series. We're kind of going to start the same way. What is the law? Where does it start? Who does it apply to? And interestingly, the section of the law that says when you don't follow it, if someone's going to sue you, it says no person shall, or you can hold any, quote, person accountable. And viewers, consumers, even some of our professionals might be a little confused by that and think it's just an individual or a human being. But that's not the case under this law, and many laws actually. Person under the FCRA covers not just natural people, but certain entities as well, and even the government. So it's not just one consumer, or you can't just sue a person like the credit collector who actually put it on. You're not suing that individual. You can sue persons, but that person can include companies like a credit reporting agency or even a government who can be a furnisher of information, for example, like student loans.
Okay, and what are some other important definitions?
So now we know what person. Let's also talk about consumer report, or more colloquially, a credit report. In the statute, it's actually called a consumer report, not a credit report, but they're basically interchangeable with a few exceptions that aren't too important here.
Okay.
But a consumer report is kind of that. It's any report of information. It can be even oral. It can be written that would generally affect someone's character, their reputation, their creditworthiness. So think about that. It's really broad. It's not just your credit to get a credit card. It can affect your reputation for a job. It can impact your insurance rate. So it has to be a consumer report. And that information, if you go back to some of our other definitions, it has to apply to the right people. And so it has to be a consumer reporting agency. So let's talk about what that is. A consumer reporting agency, or a CRA, are the people that compile this information and sell it. But really, what does that mean? Is the government, a CRA because they keep information on you in the Social Security Administration? No, because that information is not then sold to determine someone's creditworthiness. So it's very important to apply, for this law to apply, it has to be a consumer report. And then it has to be compiled, sold, or furnished, published to a third party for some value.
Okay, thank you, Aaron. And now you've covered the important definitions under the FCRA. What are the important legal standards that our viewers need to know?
So under the FCRA, there are 4 main legal standards to consider. The first one is preponderance of the evidence. Second is a negligent versus a willful violation. Third is a materially misleading standard. And fourth is something that can be objectively inaccurate.
Can you further break those down, please?
Yeah, absolutely. So let's start with preponderance of the evidence. We talked about this in our FDCPA video series. If a consumer brings a case against a furnisher or a CRA or a user under the FCRA to win, to prevail, because it's a civil lawsuit, you have to prove your case by preponderance of the evidence, which just means kind of more likely than not. You can think of a scale that would tip just barely to one side. That's the preponderance. It's 51 to 49% or 50.1, however you want to talk about it. Is it more likely than not that this happened? Which is contrasted by in criminal court, which is beyond a shadow of a doubt. It's a much higher standard. But that's kind of important to think about. If credit repair leads to litigation, if litigation leads to a contested issue, the consumer is going to have to prove that by a preponderance of the evidence. The second one we talked about is a negligent violation. I'm going to pair that with a willful violation. People that violate, persons that violate, whether that's a CRA, a furnisher, a user, if they violate any prohibition or part of the statute, they can be held negligently liable or willfully liable. And that's really important in this context because what the consumer may be entitled to changes depending on what type of violation it is. And in short, a negligent violation is basically something that was unintentional. You can think of that of a car accident, negligence claims. You didn't mean to get in an accident, but it happened and you caused damage. In a lot of these cases, the companies didn't mean to make the mistake. It's not like, hey, Johnny X, I don't like this guy, let's screw up his credit report. That would be an intentional act, but just negligent. But we compare that against what's willful or reckless.
Sure.
And at some point, negligence just isn't negligence anymore. And so, for example, if there are so many chances to fix a problem, 5, 6 disputes, and it's so obvious based on what's there, and they keep not fixing it, well, that can be a willful or a reckless violation. And the important distinction there is negligent violations you cannot get punitive damages for under this statute. But if you can prove a willful or reckless violation, punitive damages are available, which can, of course, change the whole nature of a case, the value, and punitive damages kind of drive the bus, the big verdicts that you hear about and stuff like that.
Okay.
So that's why that's important between those two standards. And then fourth is, what even matters enough to sue under the FCRA? What type of errors are material? What's inaccurate? And that's very important. So let's talk about the distinction between those two. If something's just objectively inaccurate, it's kind of what it sounds like. Bank X is saying, I paid this account late. I was over 30 days late because they say it was paid on day 31. My canceled check shows it was paid on day 28. Now, that's objectively inaccurate. Hopefully you can send that in and they would fix it. But there's a new line of cases, relatively new, that says there are other instances where something could be technically accurate, but materially misleading. And I want to give you an example. So this is a classic one. Someone gets into an accident or has a medical emergency, and they go to the emergency room, and they have insurance. So, they sign all the paperwork you do when you sign to the hospital, you get services. Guess what? The insurance makes a mistake and doesn't bill the right insurance, so it never gets paid. A couple months later, the consumer's getting debt collection phone calls, and it's on their credit report. Well, in a technical sense, there was a medical debt, and the consumer didn't pay it, right? But there's this other third intervening factor or other factors that mean, but it's still materially misleading to report that she owes this debt, that this consumer owes the debt. And that's very important. So kind of to put that into context, when we're looking at errors, when we're looking at credit repair, looking at credit reports for things that are inaccurate or incomplete, we're also looking for things that are materially misleading, even though they may be technically accurate. Another classic example. Let's say someone accessed your credit report, but you didn't give them permission to do so. Well, it's technically accurate that they obtained your credit report. So are they supposed to keep reporting that? But some judges say, no, of course not. Yes, it may be technically accurate that there was a hard pull, a credit application from this company on this person's credit report, but it's misleading to keep it there because it hurts them because it wasn't their decision. So that's kind of that example.
Got it. Okay. And just lastly, how does all this connect to the larger picture of credit repair?
As I've said many times, as our other instructors have said, you cannot understand these laws, the basic principles of credit repair, without knowing the foundation, the basics. And so this video, the second in the series, was really about what are the definitions, what definitions matter, what legal standards apply. That way we're not just flinging off letters with quoting language. It really has impact and import because it's done the right way. So use these principles, these definitions, the players that we have now finally identified in more detail to not only build better credit disputes, but also potentially set up that case for potential litigation, because litigation may be the only way to fix the problem. But then on top of it, the client's going to get some damages with very little to no risk, because Swift Law North, we don't take cases, with a retainer fee. It's all contingency fee based because we take the risk, because the statute allows that. It makes the bad guys pay. So again, start with the basics, the definitions, the legal standards, understand why the law exists, when it exists, how it's been changed. that basis is going to make everything better as we move into the disputing process and ultimately into litigation.
Okay, thank you, Aaron. As always, if you guys have any questions, you can let us know in the weekly sessions or in the chats.
Thank you.